The matter before us today is not fresh. It is 75 years old. It was filed not in this courtroom, but in the Constituent Assembly. The petitioner, the Indian Constitution, the respondent, time itself. The charge is delay and the charge is hesitation. The charge is broken promise. The issue, do we, the people of India, wish to live under one law or many? Article 44 of the Constitution states, the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Not may, not if convenient, it said, shall endeavour. Yet the endeavour never began. The promise has remained paper. The words have remained silent. Tonight, they speak. The courtroom of history is now in session. The next hearing begins. Let us rewind to November 23rd, 1948. The Constituent Assembly is in session. Article 35 of the Constitution is under debate. This will become Article 44 of the Indian Constitution. Dr. B.R. Ambedkar rises. He explains why UCC belongs in the Constitution. Listen to his words. We already have a uniform code of laws covering almost every aspect of human relationship. We have a uniform criminal code operating throughout the country. But we have yet to adopt a uniform civil code. This provision is introduced in the Constitution to bring about such uniformity. But resistance is immediate. Muhammad Ismail objects. He wants to attempt to interfere with the personal law of any community without its consent is to impose upon it laws it does not believe in. This will be a tyranny. Others echo his concern. They argue religion and personal law cannot be separated. That uniformity will mean majority dominance. Ambedkar stands firm. He says, it is perfectly possible for the Muslim community to keep its personal law for religion. But when it comes to marriage, succession, and inheritance, there can be no objection to state making laws. The Prime Minister in waiting softens the blow. He admits, I do not think that at the present moment, the time is ripe in India for me to try to push it through. And so, the compromise is struck. Article 44 is placed in a Part 4. Directive principles, not enforceable, not binding. This was the first retreat. The Constitution whispered equality. Politics postponed it. When Parliament hesitated, the court intervened. Case 1 is Shah Bano case of 1985. Shah Bano, 62 years old, divorced after decades of marriage. She sought maintenance under Section 125 CRPC. The Supreme Court ruled in her favor. Chief Justice Y.V. Chandrachud wrote, it is a matter of regret that Article 44 has remained a dead letter. A common civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. Those lines still sting, a dead letter. That is what Article 44 had become. But politics struck back. Rajiv Gandhi, then PM, under pressure, passed the Muslim Women Protection of Rights on Divorce Act 1986. It reversed Shah Bano. The promise of equality was buried under appeasement. Case 2 is Sarla Mudgal case of 1995. A Hindu man converts to Islam, not out of faith, but to marry again, to escape monogamy under Hindu law. Justice Kuldeep Singh observes, where more than one wife is permitted under personal law, but prohibited under another, the absence of a common civil code leads to anomalous situation. The government has been remiss in implementing Article 44. It is a matter of great regret. Anomalous situation, great regret. Strong words, ignored words. Case 3 is John Vallamattom, 2003 case. A Christian priest challenges inheritance restrictions. Chief Justice V.N. Khare declares, it is a need of the hour that Parliament take steps to enact a uniform civil code. Article 44 is based on the premise that there is no necessary connection between religion, and personal law. So the court pleaded year after year, case after case, but Parliament, it chose silence. Why silence? Why hesitation? Because UCC is not only law, it is politics. The BJP has promised it since 1989, Ram Mandir, Article 370, Uniform Civil Code, two delivered, one pending. The Congress, it collapsed in 1986, Shah Bano was its movement and it retreated. Regional parties, they avoided it, too controversial, too polarizing. Minorities fear, they ask, does uniform mean Hindu? Does equality mean erasure? Even Hindus are divided. Goa already follows the Portuguese civil code. North states enjoy special protections under Article 371. Tribal customs remain untouched. So what does uniform mean? One law for all or one law for most? That is the heart of delay. Politics feared clarity. Let society speak. A Muslim woman discarded by instant triple talaq. A Hindu daughter denied property. Until 2005, a Christian woman forced to fight harsher divorce laws. A Parsi woman excluded from inheritance. Different religions, same injustice. Personal laws differ, but patriarchy is uniform. Delhi High Court 2021, Justice Pratibha Singh observed, citizens of India should not struggle due to conflicts in personal laws. The youth of India deserve a common civil code. This is not about Hindu versus Muslim. This is about man versus women, privilege versus equality, custom versus constitution. What are the benefits? 1. Equality before law. No special privileges, no discrimination. 2. Gendered injustice. No personal law loopholes, women protected equally. 3. True secularism. Law is neutral, religion is private. 4. Clarity in courts. No confusion, no contradictions. 5. National integration. One nation, one law. That was Ambedkar's vision. That was the court's demand. That is the promise we still await. But fears exist. Minorities fear majoritarianism, that UCC is code for Hindu law. Tribal groups fear erasure, that custom will vanish. Scholars fear tyranny, that uniformity will ignore diversity. They ask, why start with marriage? Why not with caste? Why not with economic justice? These questions must be answered because the reform without dialogue is hollow. Uniformity without sensitivity is tyranny. Look abroad. France, one civil code, strict secularism, no exceptions. United States has religion is private. Civil law applies equally. South Africa, custom allowed, but struck down if it violates rights. And India, we live with parallel codes, Hindus, Muslims, Christians, Parsis, tribals, each with separate laws. We are the exception. But can equality survive in exception? Or must law unite where culture divides? Now let's talk about the road ahead in Act 8. What are the options we have? 1. Reform each personal law, step by step. 2. Expand the Special Marriage Act, make opting in easier. 3. Enact a UCC in one stroke, bold, risky. 4. Hybrid, allow ceremonies but enforce equality in essentials. Marriage age, inheritance, divorce rights, etc. No option is easy, but silence is not an option. What's the verdict? The Uniform Civil Code is not dead, it is unfinished. Ambedkar said, if this country is to have unity, it must have one law for one people. The Supreme Court repeated it, case after case, judgment after judgment, and yet the promise waits. So I put the final question to this court, to you. Do we want unity in law or division in justice? Do we want equality in practice or diversity in discrimination? The Constitution still calls. The promise still lives until it is answered. The next hearing continues. Thank you. This is Amod Biduri, and we will meet again in the next hearing. Thank you.